Something big just happened. Not the kind of big that trends for 12 hours and disappears. The kind of big that quietly shifts how police officers approach you, how courts interpret your rights, and how states draft laws that could directly affect your daily life. The Supreme Court just handed down a 6-3 decision that reshapes how gun laws work in America. And whether you own a firearm or not, whether you live in a red state or a blue state, whether you've ever even touched a gun, this ruling reaches further than most people realize. So let me ask you something right up front. Do you believe your state should have the power to restrict who carries a gun in public? Or do you think that right should be broadly protected nationwide? I genuinely want to know where you stand on that, and I want you to tell me in the comments. Don't just scroll past that question. Your perspective matters here, especially because what I'm about to explain may challenge assumptions on both sides. Go ahead and share your thoughts in the comments, and then stay with me, because what this ruling actually does, and what most headlines are leaving out, is far more complex than the sound bites. Let's slow this down and unpack what really happened. At the center of this case was a simple but powerful question. How much authority do states have to restrict the public carrying of firearms? For years, certain states required citizens to show a specific need, often called proper cause, before they could obtain a permit to carry a concealed weapon. That meant you couldn't just say, "I want to carry because it's my right." You had to prove a particularized threat, a documented risk, a reason beyond general self-defense. The Supreme Court's 6-3 majority struck that requirement down. And here's where things start getting interesting. The majority opinion didn't just say states can't require proper cause. It went further. It emphasized that the Second Amendment protects an individual's right to carry a firearm in public for self-defense. Not just inside your home, not just on your property, in public. That's a major shift in legal interpretation. For decades, courts debated how far the Second Amendment extended beyond the home. This ruling clarifies that public carry falls within constitutional protection. Now, before anyone jumps to conclusions, this does not mean there are no gun laws anymore. It does not mean every regulation is unconstitutional. It does not mean you can carry anywhere you want without consequence. And this is where a lot of people are going to get tripped up. The court introduced what's known as a historical tradition test. Instead of applying modern balancing tests, weighing public safety against gun rights, courts must now look to historical precedent. Specifically, whether a modern regulation is consistent with the nation's historical tradition of firearm regulation. That sounds academic, but trust me, it has real-world consequences. If a state passes a new restriction on public carry, courts will now ask, did similar restrictions exist around the time of the founding? Were there analogous laws in the 18th or 19th centuries? That framework changes how judges evaluate gun cases moving forward. It narrows the field of acceptable restrictions. Let me give you a practical example. Before this ruling, a state could argue that high population density, urban crime rates, or modern law enforcement challenges justify stricter carry rules. Under the new framework, those policy arguments don't carry the same weight. The historical question becomes central. And here's where I need to pause and say something directly to you as a traveler, because this is where people make dangerous assumptions. If you're flying between states, driving cross-country, or relocating for work, do not assume gun laws are now uniform across America. They are not. States can still regulate where firearms can be carried. They can designate sensitive places where weapons are prohibited: schools, courthouses, government buildings. The debate now is how far that definition extends. Airports are a perfect example. Federal law already prohibits firearms beyond TSA security checkpoints. That hasn't changed. But what about the parking lot? What about airport terminals before security? What about state-owned transit hubs? This is where things get murky, and murky is where people get arrested. I've seen travelers genuinely shocked at airport security because they believed their concealed carry permit protected them everywhere. It doesn't. TSA operates under federal authority. State permits don't override federal restrictions. And here's the thing. TSA officers are not interested in debating constitutional theory at the checkpoint. They follow federal code. If you bring a firearm past a prohibited area, loaded or unloaded, you're facing civil penalties, potentially criminal charges, and you will miss your flight. I've watched that scenario unfold more times than you'd think. This Supreme Court ruling does not protect you from federal aviation law. That's critical to understand. Now, let's talk about police interactions, because this is where the practical reality hits hardest. In states that previously required proper cause, law enforcement often had discretion in permit approvals. That discretion is now significantly constrained. More citizens will qualify for permits in those states. But more permits also means more firearms in public spaces. So, what does that mean for everyday interactions? It means officers will likely adjust their training. They will expect a higher probability that individuals are legally armed. That changes the tone of traffic stops. It changes the dynamics of public encounters. And here's where I'm going to give you a piece of advice that might save you a lot of trouble. If you are legally carrying and you are stopped by law enforcement, know your state's duty to inform laws. Some states require you to immediately disclose that you are carrying. Others do not. Failing to disclose where required can escalate a routine stop into a tense situation very quickly. Don't rely on what your friend told you. Don't rely on something you read 3 years ago. Laws evolve. The ruling also creates ripple effects for states that want to respond. Several states have already begun expanding sensitive place definitions in response to this decision. You're going to see litigation over whether subways, public parks, stadiums, and even entire city districts qualify as sensitive places. And here's the suspenseful part that most people aren't thinking about: the next wave of cases. This ruling sets the framework. But the real reshaping happens in the lower courts. Every new gun regulation will now be challenged under this historical tradition test. Some will survive, others won't. We're entering a period of legal instability, where the boundaries of permissible regulation are still being defined. If you run a business, this matters. If you're a landlord, this matters. If you manage a private venue, this matters. Private property owners can still set their own firearm policies, subject to state law. But enforcement varies. Some states impose penalties for ignoring posted no-gun signs. Others treat it as simple trespass. Imagine you're traveling to another state for a conference. You have a valid permit. You assume reciprocity applies. You walk into a privately owned event center that prohibits firearms. You ignore the signage because you believe your permit overrides it. That assumption could lead to removal, citation, or worse. The Supreme Court ruling strengthens constitutional carry rights, but it doesn't erase property law. That distinction is huge. Let's address something else that people misunderstand. A 6-3 decision signals a strong majority, but it also reflects deep disagreement within the court. The dissent raised concerns about public safety and the practical consequences of expanding public carry rights in densely populated areas. Why does that matter to you? Because future cases may refine or limit this ruling depending on the factual circumstances. The majority opinion emphasized that states can still regulate certain aspects of firearm carry. The fight now centers on what counts as reasonable under historical precedent. And history, as you probably know, is open to interpretation. Different historians read the same statutes differently. Some 19th century laws restricted concealed carry but allowed open carry. Others imposed location-based restrictions. Expect to see legal battles over how analogous those old laws must be to modern ones. Now let me bring this back to something very practical. If you're someone who carries for self-defense, you need to understand that the legal landscape is shifting. Just because a right is constitutionally protected does not mean it is consequence-free. Self-defense claims still hinge on reasonableness. Prosecutors will examine whether your actions met legal standards. Jurors will evaluate perception of threat. The existence of a carry permit doesn't automatically justify use of force. And if you travel, especially across state lines, you need to double-check reciprocity agreements. States recognize some permits and not others. Constitutional carry states allow permitless carry for residents, but not always for non-residents. I've seen people arrested because they assumed constitutional carry meant nationwide carry. It doesn't. Here's another scenario that might surprise you. You're driving through multiple states. You store your firearm in your vehicle. Federal law does provide certain protections for interstate transport under specific conditions: unloaded, locked container, inaccessible. But if you deviate from that standard, even briefly, you can fall outside that protection. And state police know this. Officers are trained to identify inconsistencies in storage and declarations. If you think arguing constitutional theory roadside is a winning strategy, let me gently suggest you reconsider. This ruling is significant. It strengthens individual rights in a clear and forceful way. But rights operate within systems: federal law, state law, local enforcement, property rights, and practical realities. What it means for you depends on how informed you are. If you're anti-gun, you should understand that the regulatory path forward now requires historical justification. Policy arguments alone won't suffice in court. If you're pro-gun, you should recognize that exercising rights without understanding boundaries is where legal trouble begins. And if you're someone who rarely thinks about gun laws, you should realize that this decision affects how your state drafts public safety regulations, how businesses operate, and how law enforcement interacts with citizens. We are in a transition period. Laws will be rewritten. Cases will be filed. Lower courts will interpret this decision in ways that may surprise both supporters and critics. So here's what I'd tell you if we were sitting across from each other having coffee. Don't rely on headlines. Read your state's updated statutes. Pay attention to where firearms are prohibited. Understand duty to inform requirements. If you travel, check reciprocity before you pack anything. And most importantly, don't confuse constitutional protection with universal permission. The Supreme Court has reshaped the framework. Now the details will determine how that framework operates in real life. I'm curious, has this ruling changed how you think about carrying, traveling, or interacting with law enforcement? Put your thoughts in the comments. I read them. And the next wave of changes may depend on how informed citizens engage with these issues. Stay aware, stay informed, and don't assume anything when it comes to federal checkpoints, especially if there's a TSA badge involved.